Alliance. Scott, if you can say a few words to get us started here.
Well, welcome. On behalf of the USIPA Alliance and the Global IP Alliance, we appreciate you joining us today. This really special session. UPC is almost here. What do you need to know? It's a big deal, and there's a lot you need to know. I want to give a special thanks to two really great friends and two of the leaders in the IP profession, Griff Griffin and Rob Stern. And by the way, these two guys, they've done a lot of things in their careers, and they continue to help a lot of people. And I just really appreciate their leadership and their collaboration to make this thing happen today. So with that, I'm going to introduce the moderator for today's panel. It is Rob Stern, the one and only. Many of you, if not most of you, know Rob, but I'll just give you a little of his background. He's the director of Stern, Kessler, Goldstein, and Fox in the electronics practice group, co-chair of the firm's PTAB trials practice. The very impressive story is that at age 26, just 1 year out of law school, he set out to create a different kind of a law firm, one that recognized the contributions of all its members and put a strong emphasis on scientific and technical knowledge. Now, nearly 4 decades later, Rob has helped to nurture and grow this revolutionary idea into one of the top 5 largest intellectual property specialty firms in the country. And in doing so, he has established his place as one of the leading patent lawyers in the United States, and I would say the world. So again, special thanks to Griff and Rob, and you're in great hands with Rob. Rob, take it away. It's your show. Thank you very much.
Well, thank you, Scott. And let me start by saying that we all need to thank Scott and Nikhil for all their public service. Without them, we would not be here today. And the great work that they've done with the USIPA and the GLIPA, and also the many state IPAs that have sprung up in the United States over the last 2 to 3 years, are going to change the whole conversation here long-term in the United States and around the world about intellectual property. The purpose of our conversation today, and it's a conversation, is to share with you some of the most important ideas and facts and trends and advice that we can provide about this new unified patent court and this new unitary patent at the EPO, the European Patent Office, that will go live on June 1, 2023. We're being recorded for on-demand download. Many of you are on live today. We will not be taking any questions. However, we have an outstanding group of panelists from around the EU, as well as in the UK and the United States. And so what we want to do is provide each of you with information, ideas that you can immediately apply in your professional activities. So let me start, if I may, with introducing our panel members. We're going to go through them quickly, and then we will dive in to a bunch of topics over the next 90 minutes. I will tell you that about 10 minutes to the end of our presentation and conversation, I will hand it back over to each one of our panelists for a summary statement from each person. Before we go any further, I think it's appropriate we introduce your panel. So if we could put up our panel slide. So here we have a short bio of each of our panelists, and I'll start with you, Koen, in Amsterdam. Could you please introduce yourself?
Thank you, Rob, and hello, everybody. I'm excited and delighted to be here and to share my thoughts on this tremendous change in European patent law that is coming about next week. My name is Koen Bijvank. I'm a partner in Brinkhoff, which is a law firm based in Amsterdam in the Netherlands. I'm dual qualified both as a Dutch and European patent attorney and as an attorney at law. And my specialty very much is in contentious matters, so patent litigation and oppositions before the European Patent Office. Thanks, Rob.
Well, thank you, Koen. And so Dr. Gardner, you are in Frankfurt, Germany. Welcome. Thank you for your law firm help and sponsorship of this program. Annette, do you want to introduce yourself, please?
Thank you for having me. I'm excited to be on this panel. I'm an IP partner at the new Frankfurt office of Eberschatz. And I guess the only comment I want to share up front is the UPC for me is like the running gag of legal history. And I can't believe it's actually going to go live in a couple of days. Thank you.
Thank you. Well, a lot of people share your observation, but we'll get into that more. So Jeff Langer, please introduce yourself if you would.
Yeah, hello everyone. My name is Jeffrey Langer. Now I'm general counsel. In my prior life, I was intellectual property counsel. I started my career at Finnegan and then moved over to Philip Morris International, where I led their reduced risk product line. Super excited to be here. A lot of great panelists. I'd like to thank USIPA and GLA-IPA for putting this program together.
Well, thank you, Jeff. And Mariella, you are talking to us, I believe, from Helsinki today. Well, no, actually, you're talking to us from Atlanta. So do you want to introduce yourself, please?
Yes, so I'm primarily based in Helsinki, where my firm, Bergen, has its headquarters. Today I'm speaking from Atlanta, that I use often as a hub in the United States. I have a law degree from the University of Turin, Italy, practiced in Italy for 15 years as a litigator and also licensing professional. In 2021, I passed the exam as a certified licensing professional. And so now I'm more focused on licensing. Thank you.
Well, thank you very much for being here. And we'll, of course, be back to you soon. So if we could go to the next panel slide, we've got 4 more panel members to introduce. So Amadine Paris, would you please introduce yourself?
Yes, thank you, Rob. So my name is Amandine Métier. I'm a partner at the European law firm called Oinrock Monodier. I'm based in Paris, in France. So I dedicated my entire career to patent litigation, and I'm really eager to start trying this new UPC system where I have been registered as a representative, as many of you. Thank you.
Well, thank you. So Mario, I believe you're not in Rome and you're not in Milan, but you're in Verona. So do you want to introduce yourself, please?
Yes, thank you, Rob, and thanks everybody. My name is Mario Pozzi. I'm a partner of the SIB Lex law firm. I'm an attorney at law and would specialize in intellectual property litigation, and in particular pan-European patent litigation and standard essential patent. And now I am also a UPC litigator, and I really look forward to start proceedings before the UPC. Very happy to be here.
Excellent. So Philip, I believe you're at your Munich office. Would you introduce yourself, please?
Yeah, thanks, Rob, Scott. Thanks for having me. I'm Philip Rastenborski. I'm a partner at Meissner Bolte, based in Munich. Meissner Bolte is a mixed IP firm with offices inter alia in Munich, obviously Düsseldorf, Hamburg. We have about 80 patent attorneys and lawyers working dedicated on IP matters. Again, I'm heading the litigation department, doing like 95% of my work is patent litigation, utility model litigation before the German courts, and mainly within international scope. Meissner Bolte is also a member of the European Patent Litigators Network, EPLN. You may watch out for this. Ziplex is also a member of this alliance. So we're working closely together with Mario Pozzi of Ziplex, and we're all very much looking forward to this exciting new opportunities for the UPC.
So finally, Jeremy from London, would you please introduce yourself?
Thanks, Rob. Hello, everyone. Nice to see you all. I'm calling today from London, and I'm a partner at Kilburn and Strode. In our London office, that gives me a great, interesting vantage point for the UPC. Obviously, since Brexit, the UK is no longer in the European Union, so not allowed to be covered by a unitary patent. But because the European Patent Office is not an EU body, we are still allowed, thankfully, to act before the UPC and have European patents nationally granted that cover this country. So that's an interesting vantage point. My personal practice focuses particularly on EPO oppositions as well as prosecution. I don't personally do litigation, so some of those aspects I will leave to the experts otherwise here. Otherwise, looking forward to the chat.
Well, thank you. So let's take the slide deck down. Let's put everybody up and let's start the game. So, Koen, please provide us with a short explanation of this UPC in terms of its structure, like where are the first instance courts located? And tell us what you want, and we'll start talking about the architecture, so to speak, of first instance courts and second instance courts, because I think it's important for each of us to understand what does this new system look like in terms of the tribunals.
Thank you, Rob. Before we started this, you told us that politely you would hold us to a speaking time of 2 minutes, and that is going to be a challenge to cover all that in 2 minutes. But I'll give it a go, and other speakers can supplement, because ideally the system would, of course, have one first instance court somewhere, and we would all know where to go, and that would be that one court, and that's where all patent litigation in Europe would take place. But this is a political compromise. And that means that there are various courts which are together the first instance court of the Unified Patent Court. In a nutshell, for an infringement case, you can go to any local or regional division, and each country participating in the system can have a local division. Germany is the exception. They have 4, but otherwise most countries have 1. And there is 1 regional division of the Baltic states and Sweden together. And that is where you start your infringement case, depending a little bit on the place of business of the defendant or where infringement takes place. In most cases, infringement will take place across the EU. So in that case, you can forum shop and you can select any local division of your choice. If you want to start a case as a revocation action and you want to invalidate a patent, then you go to what is called the central division. Again, that is not one simple location and one building where you go to. There are 3 of them. The main central division is located in Paris, and there are 2 others. One was supposed to be in London, and the other one is in Munich. It has recently been announced that the 3rd division will not be in London, but will be in Milan. It will take some time for that to be set up, and in the meantime, the cases that would otherwise have gone to London are being divided over Paris and Munich. So it depends a little bit. If you are the plaintiff, the patent owner, you go to a local division. If you're on the other end and you want to start a preemptive revocation action or a case for a declaration of non-infringement, you go to the central division, and then it will end up either in Munich or Paris in the near future.
So thank you. So excellent job. And I didn't time you, but I think you were close. So Amadine, you're in Paris, where you have one of the central revocation tribunals. Can you give us a better understanding of the number of judges that will be in first instance courts? What kind of judges are they? Where are they coming from? And anything you'd like to talk about in terms of the decision makers that we will be before?
So as Koen indicated, we are here at I would say also as a political compromise with a mixed team of judges and composing the panels of the local, regional or central division in first instance. The rule is that for the countries where patent litigation is quite developed, the rule is that there are 2 national judges of the local or regional division composing the panel. So for instance, in Germany, France, Italy, the Netherlands, the local divisions will be composed of 2 nationals of this country, and 1 additional judge will complete the panel of the 3 judges to have our panel of 3 judges. And these additional judge will come from a pool of judges, which in fact gather all the judges that are now UPC judges. So all these judges are legal judges. If there is a revocation action in place. There is also a technical judge that will be part of the panel, and the technical judges are taken from a list of appointed technical judges that have been published by the UPC. So we will have a mixed panel of judges from different nationalities, different cultural experience, and different legal tradition, and that will make, I would say, part of the fun of the new system, because obviously we will all be somehow, we will all have to adapt to this new construction and this new panel of people we will have.
So thank you. So Annette, it's my understanding you're in Frankfurt, but there are 4 courts, 4 local courts for the UPC in Germany. Can you give us a little bit more detail about that, and also why would say a judge that has been very successful in her country in her national courts doing patent litigation, why would that judge want to move over to the UPC?
Okay, so the reason why there will be 4 local divisions in Germany is because the vast majority of infringement cases are actually heard in this jurisdiction, and the local divisions will be in the 4 places which currently also host the leading national chambers, and this is Munich, Düsseldorf, Mannheim, and Hamburg. Now, when you ask me why somebody would change jobs, actually, if I may, I would like to twist that question a little bit, because some of the judges will wear the German hat in the morning and the UPC hat in the afternoon, because they're not all 100% judges. Some of them only have 20%. And I guess, and it's only an assumption, some of the reason why you want to become a UPC judge is because eventually the UPC system will be the stronger one. This is where cases will be heard and people don't want to lose out. So the good decision to take is to actually join the ship while it's sailing and to write legal history and influence the rules, which are somehow being made up while case law develops.
Well, good. And Philip, you're sitting in Munich. Munich, of course, being one of the most lively and important cases today for patent enforcement and infringement and revocation in Europe. Can you tell us why you think there is so much interest from the top judges in Europe with the UPC, and tell us a little bit about how the UPC is funded as an organization, please.
Yeah, sure. Basically, I can only agree to my colleague Annette. The major interest and driver for many of these judges is certainly the point that in the mid and long term, the case law of the UPC and the Court of Appeal of the UPC will harmonize and set the tone and standard for patent litigation all over Europe, all over the EU, not only as regards claim construction, determination of patent infringement, but also determination of patent validity. So, and this is a good chance for many of these judges to be in the forefront to set the tone of these rules. Of course, there have been a lot of ambiguity. How will this new court behave? We don't know. We have no case law. A new system always brings uncertainty. But since the names of the judges are out, many people are relieved that actually it has been a selection of really the judges who are best in class in their national jurisdictions. Be it Germany, be it France, be it the Netherlands, these are really the top judges that forged case law in these jurisdictions before. And when you ask how is the system financed, well, it is a self-financed system. So in the mid and long term, it is the idea that this UPC will bear on its own fees it generates from cases. So to a certain extent, this court is under pressure to attract business in competition also with the national jurisdictions and with other jurisdictions around the world, the US and China. Attract cases, make good case law, and who is your customer? Who will pay the fees? In the end, it's of course the patent owner who wants to save protection for his patents and a good scope for his patents and a big scope of enforcement. So many scholars argue that at least in the beginning, the UPC might be a rather patentee-friendly court to attract these cases all around the world, to bring them to the UPC and make good case law.
Well, great. And Mario, I know you're sitting in Verona at the moment, of Romeo and Juliet fame, your home city. But can you tell us a little bit about the composition of the local court, UPC court in Italy? And what about this statement we heard at the beginning from Kuhn about this central division change from the UK to wherever? Can you help us out there, please?
Yes, of course. Thank you, Rob. Actually, I'm here in Verona, but I'm based in Milan. My office is there, so. Well, the local division, the UPC local division, as all the local division, will have 3 legally qualified judge, plus, as also my colleague Amandine said, plus 1 technically qualified judge in case in case there is a counterclaim for revocation, for example. So the local and regional division will handle the infringement action, but as usually happen in patent litigation, there will be likely a counterclaim, and in that specific case, a technically qualified, of course, will be added to the panel. I personally know that the 2 judges of the local division, who are Italians, Mr. Perrotti and Mrs. Zana, who are, of course, judges of the specialized division on company matters in Italy, so the division specialized on intellectual property litigation, and they are excellent judges, so we are very happy to have them also in the UPC. And as Kuhn said, likely we will also host the central division. We do not know if the Milan central division will hereditate all the competencies of the London central division. We strongly hope so. So both human necessity, chemistry, and metallurgy. That for the time being, if I'm not wrong, human necessity went to Paris and chemistry and metallurgy to Munich. But there are also rumors that some of the London branch competencies, such as SPC, could also be splitted among the central divisions. So it will be interesting to see what kind of competencies Milan Central Division will have. We strongly hope that Milan will have all the competencies that was at the beginning assigned to the London branch of the Central Division.
So, Mariella, I believe Helsinki will have a local court. And I also believe that, or understand that Stockholm will have a regional division, regional court. Can you explain how that's going to work in Scandinavia?
Yes, so Stockholm has a regional court, so it has competence over Sweden and 3 Baltic countries, so Lithuania, Latvia, and Estonia. Helsinki will have a local division of the court that will have competence over Finland, and we will have 1 judge from Finland and 2 that will be appointed by the pool of judges. And to my best knowledge, the languages that will be allowed for infringement cases in Finland in front of the local court are not only Finnish and Swedish, but also English. So there are several local divisions that are allow English as a language.
So it's my understanding that neither Spain nor Poland will be part of the original 17 countries of the UPC. To outsiders of the EU, I must say that's an interesting development. I understand there's politics involved, but of course, it seems to me as an outsider of the EU that if you were, say, manufacturing or distributing in these jurisdictions, you could basically use them as gateways into the EU. So Koen, can you explain how a patent owner is going to be able to control infringement if it's coming out of Spain and Poland, since they're not part of the UPC at the moment, but they are in the EU?
Well, there are various options for that. The simplest and the most obvious one, of course, try to enforce your patent in the courts in Poland, Spain, and the UPC. Although that is exactly what the whole UPC system is trying to avoid, making it centralized so that you only have to start one action in order to put a stop to infringement across the EU. Unfortunately, that is not yet possible. However, having said that, once somebody, like you say, uses either the Spanish market or the Polish market as some sort of a stepping stone into the EU, if you only enforce your patent in the UPC, you may not be able to stop them from infringing in Spain or Poland, or you may, it depends a little bit on the circumstances. But in any case, once the product is then imported into any of the UPC member states, then for sure you can sue them before the UPC. Now, depends a little bit on the situation, but if the defendant, i.e. the infringer, has a place of business or is domiciled in any of the UPC member states, then the UPC might still have jurisdiction to adjudicate that infringement action, even though some of the actions, some of the activities are taking place in a non-UPC member state. And the reason for that is that the UPC is a European court and has to apply European law. That means it also has to apply the Brussels regulation on jurisdiction. And in that regulation, there are some provisions added on the basis of the UPC agreement, allowing the UPC to also accept competence or jurisdiction in situations such as this, where one of the defendants, at least, has a place of business in a UPC member state and is involved in infringement also in other EU member states. So that's a fairly straightforward possibility where the UPC might still have jurisdiction also for Poland and Spain, even though they are not part of the UPC system.
So everyone should know that having spent hundreds of hours with these individuals and others trying to understand this new system, and thank you, Koen, for an excellent summary of a very complicated topic. The thing that I find so fascinating about this is the complexity that is actually produced. We should know, for example, that for the next 7 years, you're going to have a parallel system. And we'll get into this opt-in, opt-out topic in a moment. But the point that I'd like to make to all of you is that you could have parallel proceedings in the UPC and in national courts, and probably will in many of these situations that are about to start. So Jeremy, you're in London. You're an EPO patent attorney. You mentioned at the beginning of our conversation that EPO patent attorneys have right of audience at the UPC. Can you explain what that means and how is the UK going to fit into this new system? What's going to really happen from London?
Yeah, it's going to be an interesting change, I think, for everyone here, particularly on those on the litigation side. I think traditionally in the UK and Europe, firms have been traditionally either a litigation firm or a prosecution firm, and already we've been seeing changes in Europe of firms merging those things. I've been in the profession long enough to remember 2014 when the UPC was about to open, and various firms in the UK were starting to, if they were prosecution firms, starting to hire some solicitors, the litigators, or vice versa. And then, of course, the court didn't open. Some of the firms have carried on anyway and done well. Others have struggled a bit. So the landscape's been changing. I think the bigger change is on the litigation side, because the litigators have potentially most of their future work will be at the UPC, so they really need to get involved there. On the prosecution side, we had our European integration stage in the late 1970s when the EPO was formed. So I think the change for us is a bit less severe, but there could be some interesting developments there as well. And having the right of audience is interesting. It's questionable, yeah, how much we're going to use them as patent attorneys. But I think in general, the best situation for a UPC case will be to have a team that includes both patent attorneys and litigators. This is common in some European countries already, but in the UK, typically litigation is handled only by litigators without patent attorney involvement. I think other countries are more used to the merging going on, whether that's merging within a firm or different firms cooperating. But there's a lot of shuffling going on, and a lot of people are going to be changing the way they work soon. So it's an exciting time.
So Jeff, you're a general counsel and you're also a patent attorney. You've worked in Switzerland, you've worked in China, you've worked in the United States. You're technically trained. You're both a lawyer and a patent attorney. Tell me, from your perspective, like what are your big points that you would like to begin sharing about what's going on here from the US side?
Well, I think the initial point is, look, there's a lot of complexity to unpack here. I was taking some notes as we were going through. You and Jeremy were talking a little bit about dual proceedings and how that might play out. Cone was talking about, point of manufacturing versus point of sale as a jurisdiction that you're going to want to look at. Amandine was referring to this as fun, and I understand she meant that in an intellectual way. It's a little bit terrifying as general counsel with a company where ultimately you need to communicate a highly complex change in how patents are going to be playing out to business folks that honestly have no patience for nuanced points of law. They don't want to talk about, they don't want to talk about invalidity. They don't want to talk about, they want to know what's on the table, how much are we going to have to pay to get there, what's the likelihood that we get there at the end of the day. I think Annette and Philip also were focusing on another strategic element here. Do you need to jump in now? Do you need to find cases that make sense for you? Because the law is largely unshaped there. And I think as this system in its kind of embryonic state becomes fully developed, that's really going to have a significant impact on you as a company. A couple other things the broad point is there is a need for strategy here. There's a need to engage today on, are we opting in or are we opting out, or do we have some kind of split strategy? And that's very bespoke, right? That is not something you can do with a broad brush. You need to understand, in-house counsel need to understand their business. They need to understand their exposure in Europe and what are you going to do next. Again, I touched on just some practical issues. If you are buying or selling in Europe, you have some exposure. If you have competitors in Europe, there is some exposure. If you're sourcing a key component out of Europe, are you talking to your clients about, hey, I'm IP counsel, and usually I don't start looking at your contracts, but are you indemnified? If your manufacturer is not kind of keeping track of the IP space, do you have delivery terms that are locked up? So if you lose that critical component, you can break free of the contract. One thing we haven't talked about yet, and I think is, for me, still remains okay, what's going to happen is director liability. This is an unusual concept for folks in the US, absent bad faith. The Germans, as I understand it, routinely do this where they pull in directors as on a personal liability basis for patent infringement. And it's not you knew or should have known you were committing patent infringement. This is almost like a strict liability offense. That's a huge issue for in-house counsel. We have to talk to the board. We have to protect our directors. We should be looking at D&O policies today. Does your D&O policy contemplate a US director, for example, getting pulled into Europe on a personal liability basis for patent infringement? My guess is most folks have not had that conversation, and we're less than a week and change out before that happens. To me, I think there's a lot of unknowns here. There's a lot of complexity. As you stated earlier, Rob, I do not think a lot of US attorneys are paying attention to this, but if you have a client with significant exposure in Europe, you need to have a strategy, and you need to have it really fast at this point.
Well, great. And so Ahmadin, he said fast. He said fast. So could you walk us through the rules and the timelines and the steps for first instance decision-making in this new UPC court system, please?
Yes, sure. Maybe one thing to keep in mind is that it will be very fast proceedings when compared to existing national European systems, except Germany for the infringement proceedings. But there we are discussing proceedings that could be consolidated, so both validity and infringement, and the time frame announced in the rules and the UPC agreement is to complete this entire phase of liability, so infringement and validity within a year. So it really fast proceedings, because when compared to other existing systems, we are rather in a longer time frame. So what you have to keep in mind is that deadlines will run very fast, and we know that from discussions with the UPC judges that they will not be very keen on granting extensions of deadlines, although it is possible in the rules. But I think they are really eager to have the system work efficiently, because it is really one of the main points of this system, to be quick and efficient. And so we will have a very, very tight deadlines and time frame. And if we speak to only revocation action, for instance, it's even shorter than a year. So it's really something to keep in mind, which means that from a preparation perspective, it's really important for all of you to be ready to face this kind of litigation and not to wait too long to react. Just because, for example, if you want to raise any preliminary objection with respect to the local divisions that have been seized, or the language used in the statement of claim, you only have a month to do that. And a month is, going very, very fast, and it's important to be ready for that.
Well,
I'm sorry, Rob, go ahead.
No, you go ahead, please.
No, Amandine, I think you've hit another nail on the head. If we look at a 12-month cycle, contrasting that to US litigation, right? PTAB and IATC proceedings run roughly 18 months, and those are challenging to manage. Again, I'd go back to if you do not have a strategy today, you are really setting yourself up for failure, because you need to be looking at your EPO, FTO strategy. You need to be talking about protective letters. You need to because you didn't even touch on the preliminary injunction and ex parte preliminary injunction possibility here, where it is one of in-house's biggest challenge is marshaling the resources, right? You know, you've all dealt with outside clients before. You know, we tell you we're going to get something, and then we tell you we're going to get it to you 48 hours later. We're going to tell you we're going to get it to you 72 hours later. It's really challenging to marshal those resources. 12 months is going to be an incredibly fast proceeding. And if you're not teed up
Exactly.
on the side or the
Main
opposite side, you're really going to fight.
Yeah, and that's one of the main reasons that drove this presentation today, everyone, is you better be ready. And we're going to talk more about what you need to do to be ready. So let us start diving into some of these topics. But before we get to that point specifically, I think it would be helpful to continue with our conversation about timelines. So Kuhn, you know, we have these first instance proceedings. How does damages fit in? And could you explain what second instant review is, please?
So damages are not assessed in these first instance proceedings that take about a year. That would only be to establish liability and validity of the patent, assuming that there is a counterclaim for revocation, which in nearly all cases there will be. So in about a year, you will have a decision as a patent owner saying that company X infringes your patent, and most likely there will be an injunction that will be enforceable almost directly. You may have to pay a security on request of the defendant, for instance, to enforce the injunction, but the injunction is immediately enforceable. Once the liability is established, then of course, you know, you're also entitled to damages, but the first instance court in that proceeding will not determine the amount of damages. For that, there is a bifurcated system. That means that with that judgment in hand, you start a new proceeding as a patent owner for the assessment of damages. That is a system that exists in many European countries already today. Germany is an example, the Netherlands is another one. What you very often see is that the infringement and validity part of the case plays out up until appeal, so in the second instance, and only after that are these damages proceedings initiated, if at all, because in that situation, very often there will be a negotiation and a settlement on the amount of damages. Whether that will be the case in the UPC as well is something that we will have to see. But my expectation is that it will be some time before we see any damages proceedings at all in the UPC. I think everybody will be going after an injunction because that is really a powerful weapon.
So, Philip, so we have this first instance that's going to be super fast, as we would say in the States, a rocket docket is one phrase often used for our district courts that used to go super fast, like the Eastern District of Virginia 25 years ago, which is no longer super fast. So I know you're very experienced with litigation in the German courts on the issue of infringement. But my question, I guess, for you is how is this appeal going to work to this second instance court? Where is this second instance court, and what is the standard of review of this liability determination from first instance courts? How does this work?
Yeah, after the first instance decision, as we've heard, is meant to come about 12 months after filing the complaint, we should have the oral hearing, and then we have probably another month or 6 weeks till the judgment. Then you might have a decision that very likely involves an injunction if patent infringement is established and the patent in suit is held to be valid. This first instance decision is provisionally enforceable. So subject to security for costs, you can enforce this injunction in all the member states where your patent is valid. And but of course you have the option to file an appeal to the appeals court. This will be just one court if you compare to the first instance. It's a court located in Luxembourg. Again, here the judges are coming from all the participating member states. Where again we have very famous, renowned judges from all the member states. There are among them there are two judges from the German Federal Supreme Court, from the Patent Senate of the Federal German Supreme Court, and in essence, also the second instance is meant to be concluded within about a year from filing the appeal. And it will be a de novo hearing of infringement and validity. But again, we have very short timelines and a paper-based system. So the pressure, again, is on both parties to manage, actively manage these proceedings together with the court.
So it's my understanding, Annette, that the appeal to this second, second instance court in Luxembourg City with these leading judges from around the EU, they will apply a de novo review standard for both legal and factual issues, from what I've been told. Can you tell us if that's correct? And also, how is, where do we look for the law of this new court? Does it come from statutes? Does it come from some kind of case law, from the decisions of national patent infringement cases? How is, for us outsiders of the EU, how do we assess EU law, and what role does this second instance court play in the creation of this new body of law?
So with almost every provision in the UPC agreement, you can take at least two different positions on how you want to interpret it. I just listened to Philip and I understand his point. If you take a look at the UPC agreement, you can also take a different view, because it actually says that the Court of Appeal has discretion as to whether it will consider new facts and new evidence. So again, that's open to interpretation. My understanding is that it will focus on errors of the law, but again, it has discretion to also consider new facts. And your question of who actually decides what the law is spot on, because it'll be the Court of Appeal. And actually, we have every reason to assume that this court will be super busy by the end of this calendar year, because there's a big discussion about the availability of preliminary injunctions. And I can bet you everybody who will be served a preliminary injunction will immediately appeal, and the case will end up in Luxembourg.
Wow. So preliminary injunctions, boy, I mean, in the United States, good luck. You'll never get a preliminary injunction in a patent case anymore, particularly if the patent hasn't been litigated in the past or gone through, say, proceedings at our Patent Trial and Appeal Board. And we'll come back to oppositions in a moment, Jeremy, so hold on, please. But going to Mario. Mario, please explain, what is this preliminary injunction threat that we need to be worried about?
Yeah, great. There are different very powerful tools, judicial tools that you can activate before the UPC. So one of these, of course, is preliminary injunction proceedings in order to obtain an injunction or a seizure, also of movable and immovable assets. Or you could also ask the UPC for a provisional order in order to preserve evidence. And we are, as Italians, and we also have French friends who are very familiar with the description proceedings, which is, of course, a way to describe the infringing product or the infringing process, or again, a seizure of this kind of infringing or allegedly infringing products or process, or also the inspection. So you can go at the premises of the infringer in order to assess whether or not what are they doing. It's interesting because you can also obtain this kind of order, so-called ex parte, so without the other party being heard, and the other party will see the patentee coming with the bailiff of the court at their premises in order to describe or seize some of the products or process. The court will also have the possibility to give the defendant the possibility to file an objection, or to summon both parties to an oral hearing, or to summon just the plaintiff. And in any case, the person who receives such an order will have to start proceedings on the merits within 31 working days or 20 calendar days, whichever is the longer. Is 31 calendar days and 20 working days, whichever is the longer. So it will be a very powerful instrument, and as also Koen and Philip said, we will see a lot of this kind of preliminary injunction before the UPC.
So Ahmadin, way back when, I remember being at the office of your, I think, prior firm, and there was a very famous book written on saisie,
Yes.
which I have a copy of in my office, which was given to me by some of your colleagues. And so the question I want to ask is, Jeff and I come from a country where we have massive discovery rules that take up massive amounts of time and money and produce massive amounts of information, most of which is useless for patent infringement, but the attorneys like it in some sense. Can you explain how discovery and saisie and all the stuff that Mario was talking about is going to work in practice as you understand it in the UPC?
Yes, sure. So maybe first, as for all you to know, there will be no discovery as you may know it in the US, in the sense that it is a front-loaded system, in the sense that the claimant has to bring evidence of its claim in its submissions. And so because we have no discovery rules in Europe or no disclosure like in the UK, so the UPC has implemented this instrument that we all have in Europe with more or less experience, as Mario said, in Italy, in Belgium, in the Netherlands, and in particular in France, we are very used to do a search and seizures. So this system has been implemented in front of the UPC. So it may be, as Mario said, an order. You ask for an order for an ex parte inspection of the defendant's premises to gain access to evidence, material evidence of the infringement. With, I would say, the main difference is that if the judge considered that your claim requires that the defendant be heard, then he can bring the defendant at the bench and say, well, I want to hear both parties on that claim, which is clearly the main difference with the search and seizure as we know it currently in our respective national system, where having an ex parte order is really the importance of this kind of proceedings, because it avoids the defendant to destroy or dissimulate everything once someone knocks at the door with an order. And this is why maybe we can make well, we can jump on another subject from that. This is why it is important to file protective letters, because protective letters, as are currently known, for instance, in Germany, will be available in front of the UPC and may lead the judges receiving an application for an ex parte measure for preserving evidence, or even for a provisional injunction. Having a protective letter registered at the UPC on the very patent at stake may lead the judges to say, well, there are serious issues there in relation, I don't know, to the validity or the infringement of the patent, and I want to hear the other side before granting the order. So it's really important to have that in mind when you fear you could be the subject of either a search and seizure order or a preliminary injunction order.
So thank you. And Philip, I want to talk a little bit more about protective letters as a prophylactic strategy that we all need to be advising our clients about. And then we're going to jump into this very important topic of opt-out which we'll get to in a moment. But before we go there, Philip, give us a little bit more detail because Ahmadin has opened the door about protective letters, which I think is exactly where we need to go to next. What do you want to say about that?
Yep. Protective letters, which are provided by the new system. We know this from the German proceedings. It's more or less a preemptive defense to an expected application for a preliminary injunction or other preliminary measures that the court could issue, maybe a seizure measure or different kinds of preliminary actions that are foreseen by the proceedings. Preemptive defense may involve everything, may involve the challenging of the patent being subject to the jurisdiction because of an opt-out filed. But of course, the main arguments are non-infringement arguments and arguments of lack of validity of the asserted patent. Again, this is more or less a rather common procedure already in German, in the German practice. We usually file protective letters once some of our clients see in FTOs or in patent researches that a competitor may be close to be granted a new European patent, or where he received a warning letter or notice letter that there's a patent around, and the patentee believes that this product, that the patent is infringed by a product. These are usually the situations where you shall file a protective letter. So currently, we advise our clients that have a protective letter already pending in Germany against the European patent application or a granted patent to do this at the UPC as well. So not to be surprised or overwhelmed by an ex parte PI injunction. Of course, the system provides for securities, and the ex parte injunction should be the exceptional case. However, since we don't have any case law and we don't know how the different local divisions will handle these provisions that provide, as Ahmadin and Annette rightly said, provide the judges with a lot of discretion, especially when it comes to preliminary measures. It's definitely a wise thing to do if a company has the feeling that there might be something coming from any direction, to file this protective letter to be already on alert and to avert injunctions or other measures, harmful measures, and provide dedicated facts.
Well,
Rob, can I jump in real quick too? Because I think it's an important point for in-house counsel to recognize. One, these are confidential letters. Two, they're extremely inexpensive to file. I mean, this is really a very low cost prophylactic measure that's going to prevent the surprise of a preliminary injunction, ex parte, or other things that are much more challenging to overcome.
I was just going to comment on the confidentiality. It's right that they are confidential until the patent owner files an application for a seizure. Then the patent owner will receive a copy of the protective letter. And you would not know as a potential defendant, because what might happen, and this is something to think about in your strategy, the patent owner can then withdraw their application while having learned your arguments and then be better prepared for the next step. So when you draft your protective letters, I'm still of the opinion that it's a good idea to file them as a defensive measure, but you may not want to spill all your beans and include all your arguments in the protective letter. It's something to apply strategy to.
I think it's a great point, going. I think it's, again, this goes back to you've got to have a strategy at this point. You've got to start thinking through this, and you need to be talking to European Council, because if you do not, kind of take all these factors into consideration, you could spill all the beans. You could make the situation worse, and that's something you need to address now.
Right. Yeah, absolutely.
So Jeremy, yeah, go right ahead. Sorry.
One quick comment. Spot on, Jeffrey. Talk to European Council because they will also monitor for you what's happening in the various jurisdictions and track whether that is being transposed into the new system. And the preliminary injunction is a good example because after a recent CJEU decision, a prominent German court takes the view that there's a presumption of validity and they're prepared to give preliminary injunctions no matter how young the patent is and whether it's been tested before. So if that is transposed into the new system, that's something I think you want to know.
Yeah.
And
Yeah,
I think this brings us to an overarching point. It's not only the protective letters where companies should act right now and develop a strategy. We've also seen that even in the proceedings on the merits, we have very tight time frames. So a decision within 1 year, you have to file a counterclaim for invalidity within 3 months' time. So you have to be very quick on searching prior art and develop non-validity and non-infringement arguments. This all speaks in favor of getting to know your counsel on time. Look for your right counsel that has also the capacity to handle the cases you might expect or to cover your exposure you might have in Europe. Because once you're served with an action, be it a PI application, be it a complaint and proceedings on the merits, it might be too late. You lose the first month in looking for your counsel, and then the clock is ticking from day one, right?
Yeah.
And Rob, I'm sorry to jump in, but I mean, I completely agree with all my European colleagues. I mean, it's not just counsel, right? You need to have experts lined up potentially. It needs to be a full-blown strategy if you are exposed in Europe, and whatever that means. You know, you're sourcing a critical component, it's a major market for you. If you are not having those conversations now, 3 months is going to go very, very fast. And the other issue for most Americans, most American counsel, is the ability to amend. So you need to have not only counterclaims, not only your argument set up for the existing patents, but what's their next best position? How are you going to anticipate that? And it's a bit of crystal balling, but it's strategy work that you can do on the front end. If you're trying to do it on the fly, it's enormously challenging.
So we've opened up a lot of really important topics. So I want to drill down a little bit on two of them. Thank you all. First of all, Jeremy, going back to you being an EPO lawyer or attorney, would you please explain what a standalone revocation is? And also, how does that fit into oppositions at the EPO?
Sure, thank you. So yeah, as some people have mentioned so far, in the UPC, as well as infringement actions, you can have a revocation action, and quite often the two will come together, but you can file a revocation action on its own at the UPC to revoke a granted unitary patent. So the interesting contrast there is that there is, of course, the existing EPO oppositions procedure, which is where I spend a lot of my time. So now there's going to be essentially two ways to attack a European patent. There are some key differences between the two. Firstly, of course, an EPO opposition covers all of the countries that you might get protection from a European patent from the EPO, whereas a revocation action at the UPC will only cover the UP countries, so some of the EU countries. Secondly, a revocation action can be filed at any time at the UPC, but EPO oppositions have a deadline of 9 months from grants to be filed. And I think that's quite a crucial point. As things stand in national litigation, my perspective is that you don't see many revocation actions filed in national courts. I think the general reason for that is you can always wait until you get sued for infringement and then apply for revocation then. And also it's expensive to do and there's no deadline. So there's no particular reason to spend lots of money revoking one particular patent. Perhaps the other side would have never used it against you anyway. With the 9-month deadline at the EPO, you have a decision to make. You either attack it now or the chance is gone. Of course, now we've got the UPC revocation action option, but doesn't tick all the right boxes necessarily. So I think because of the 9-month deadline, it's going to encourage people to still use EPO oppositions. And I think other factors that are relevant include that it is generally a lot cheaper than a revocation action. Both the official fees and generally the size of team involved will be much lower. So I think while you might still want to attack a patent speculatively at the EPO without having been sued for infringement, my guess is that revocation actions will only happen in general after infringement has been brought in. Another point I'll briefly make is that the EPO is strict on what we call added subject matter. So if an amendment was made during prosecution that doesn't have support in the application as filed, quite a lot of EPO patents fall down on that front, but most European courts aren't as strict on that point. So it's possible that the UPC will also be not so strict on that sort of area, and that would make an EPO opposition still the most strong way to get an attack of that kind. And one more point finally, as mentioned, the EPO is fairly slow on its oppositions and a lot slower than the proposed UPC timelines. Particularly, of course, a UPC action could be started as soon as a patent grants, where you have to wait 9 months before an opposition can even start. So a quick UPC proceedings would whiz through before an EPO opposition has got very far at all. But the EPO is speeding up a bit, including its appeals. But the timescale is usually sort of a couple of years for an opposition. Currently 2 to 4 years for appeals, but probably going to be more like 2 soon because they seem to be speeding up. So the speed is a factor, but of course, with a 9-month deadline, you have to make a decision. And that I think because of that, that will mean that a lot of oppositions continue to get filed.
So, Mariella, we have been dancing around this idea that there is a parallel system here. There's the UPC, and then we still have for the next 7 years, national courts that can entertain or have jurisdiction over infringement actions in that country. Could you explain what this concept is of opt-out of the UPC? What is that about? Because we need to touch on that, and I'm cognizant, that we've been drilling through all these topics at fast pace, but we're running out of time. So, talk to us about opt-out, please.
So, if you wanted to subtract your patents from the competence and jurisdictions of the UPC, you need to opt out. So you file an application to opt out. That's very important to take into account now. Like, we have the sunrise period that will end on the 1st of June. This means that during the sunrise period, you can opt out and your patent is not at risk. After the sunrise period, it's possible to opt out, but in the meantime, someone can file an action in front of the UPC. Since I focus on agreements, I would like to remember that if a patent is co-owned, the consent of all co-owners is needed to validly opt out. So now it's really the time, if you didn't have this conversation with the other co-owners, to speak and negotiate your position with respect to the opt-out, because the time is really running out.
Yeah, and I think the university community, for example, where there's a lot of licensing, I'm not sure that the university community, even in the EU, has really gotten their head around what's going on. Is that right?
Yes, we have been speaking with many universities around the world, also US universities, which of course focus on licensing. And this is, of course, a conversation that it's just been started. In particular, since we have explored the many nuances in the litigation in front of the UPC, I would like to remember at this point that it's true that under the rules, it's only the patent owner / licensor that has the right to opt out, but there are many things that can happen in the new system, and the licensee can interfere with the rights of the licensor to opt out. And I refer, first of all, to the pinning effect. Any action that is brought either in front of the UPC or a national court will pin that patent for its entire life in that system. So the patent owner cannot opt out or cannot withdraw the opt-out for the entire life of the patent because an action was filed in front of either systems. And this can happen because either our license agreement contains the provisions that allow the licensee to bring autonomously an action in front of the court, and also in view of the UPC agreement, where Article 47 will says that an exclusive licensee has the right to bring an action in front of the UPC, provided the patent owner is given prior notice. Prior consent is not required.
So Koen, you know, in the United States, we don't have a loser pays system. Is there a loser pays system in the UPC?
Yes, there is, and it depends on the value in dispute. So both the court fees and the attorney costs, the cost award, are in the end determined by the court on the basis of a table, if you will, depending on the assessment on which the court will hear arguments from the parties about the value of the case, the value in dispute, and that will set a ceiling to the cost award that is recoverable.
Yeah, so going back quickly, Mario, to the point that Mariella was bringing about the so-called torpedo effect of where you opt out your patent and then a challenge of that opted out patent occurs in a national court, and now you can't opt your patent back into the UPC. Do you think this is going to be, can you explain this a little more? And do you think this is going to be a strategy that a lot of your clients are going to use?
Sure. Yeah. As Mariella said, you can opt out your European patent, but then if you discover that, for example, there's an infringement spread out to all the countries where your European patent has been validated, you would like to jump in back in the system, so withdraw the opt-out and go back into the system. If these infringers start an action, for example, in one country, also if it then abandon it, your patent will be locked out forever. So we call it opt-out torpedo or lockout system. And of course, if your patent is already involved, as also Mariella said, in a litigation in one of countries, and you decide to opt out that European patent, if one portion of that European patent is involved in a litigation and you opt out that patent, also in that specific case, you cannot withdraw the opt-out. You will stay forever out of the system. And this is very, very interesting, especially as you mentioned, Rob, since for these first 7 years, there will be the possibility of having parallel cases. So it will be very interesting to manage the strategy, to understand where to enforce some national portion of the European patent. If you start an action based on a national portion of the European patent, you could parallelly start a UPC action with regard the other two portion of the European, 2 or 3 or more portion of the European patent, carving out the national portion which is already involved in a national litigation. So the framework is really challenging, and all this kind of strategy will be very important, especially to know.
Yeah, and it's just
make a comment on that.
Sure, go right ahead.
It's perfectly true, and that's set out fully correct. It's a lot about talked about the opt-out torpedo, but I think again it's a question of strategy, and brings us back to Jeffrey's point. Is it a wise strategy to say I opt my patents out now because I consider them a good litigation candidate, and I opt them out now to wait and see if the UPC is developing properly, with a risk that I'm locked out of the system by this opt-out torpedo? I don't think this is a wise opt-out strategy. If you consider it a good litigation candidate, keep it in the system. if it's a good candidate, central attack is not so big an issue effectively. Otherwise, you always have the option with a diversified patent portfolio. Usually, have divisional filings. You may have parallel national patents that you can still enforce on the national route if you select so. But this idea of opting everything out, wait and see what happens, and get back in, I doubt that this is a viable strategy. But I just want to mention that because it's often discussed, but I doubt that this is helpful for many clients.
Well,
Yep.
as moderator, I have to watch the time. So we are down to our last 10 or 12 minutes. I think it's fair to say that our panelists have done a fabulous job of reducing a very complicated system to a lot of very important basic ideas that we can all understand, but obviously we've just scratched the surface. So I'm now going to allow each one of our panelists about a minute, maybe a minute and a half at the most, to do a summary or recommendation of what they think you need to think about in the next couple of days and months as we go forward. And I would also like each panelist to indicate to us whether their team is going to be bringing any kind of action at the UPC, whether it be enforcement or revocation. So let's start with you, Cone. You've got the floor.
Thank you. I will start with that last question, if I may. We are currently preparing both offensive and defensive actions, so revocation actions and infringement actions in the UPC. So I'm really looking forward to that. I'm filing them hopefully soon next week when the system starts. As it comes to a takeaway message, I think many of the things that we've all said this afternoon or this morning, depending on where you are, is it's all about strategy and preparation. And one may think that the UPC can be avoided by filing opt-outs and then staying out of the system, but that's only one side of the coin, because your opponent might be a patent owner who has their eyes set on enforcing their patent against you in the UPC. Besides that, it's going to come regardless after the transitional period. So it is an important development. It's a landslide change in patent litigation in Europe. And I think it's important to think about it and to think about it now. But it has many opportunities as well as threats. So it's important to make the right decisions and think about them early on. Thank you.
So Amadou, you're next.
Yeah, maybe one word to summarize what we said during this session is anticipation. So anticipate what you will be doing, either as an offensive litigation or defensive litigation. You have to have a team of counsel, prepared to be up and running on this subject, and really anticipation is key. We talked about the very tight deadlines, and really it will involve large team to be ready to be working on cases. So anticipation. And to reply to your question, Rob, as to whether we are preparing cases, I can confirm we are preparing offensive cases and defensive strategies currently.
Great. So Jeffrey, you're a general counsel. What's your parting thoughts?
I just echo what my colleagues have already said. I wasn't picking on Amandi before where she said it was fun. I mean, it is. I mean, intellectually, this is a rich playground for counsel to bring real power to their clients in a way that I think we haven't seen before. I mean, I really see this as a director, board level type issue. I mean, you're going to have your portfolio valuation impacted, the potential of director liability that may come into play, just the what are you doing today on your freedom to operate in Europe? How are you going to alter that? And you've got, a bunch of really smart folks that are thinking about this deeply. I've been really impressed with all the counsel's comments on this. But if you are in-house counsel, this is not, you do not want to be surprised.
Mariella, you're next.
Yes, I think that for entities that are involved in licensing or they have co-owned or will have co-owned patents, review your agreements, existing and future, and think about questions like which patent will be requested at the end of the procedure. You want a unitary patent or a classic European patent? Who will decide opt-in, opt-out? Who will have the standing to sue? So there are rules in the UPC system, but license agreements or agreements in general can also play an important role. So focus on these questions.
Mario.
Yeah, two suggestions, two takeaways. The first one, now it's time to assess whether or not to opt out your patents. So it is difficult to give just a general suggestion, opt out or stay in. It depends on the type of patent, weak or strong. It depends on the type of competitors, in what kind of markets you operate. If your patent already resisted to some litigation, it has been limited or not. So opt-out assessment, we call it, patent by patent. This is one crucial point right now. And the second issue, I know that General Counsel doesn't like nuance and legal. I discuss a lot with Jeffrey. We as a lawyer, we love that nuances, and this new system have a lot of these kind of nuances. There are 382 rules of procedure, 89 rules in the agreement. Really complex system, but within this complexity, you can make fantastic strategy. So you need to understand and to know and to learn this new system.
Thank you. Philip, are you going to do something, and what are your recommendations?
Yeah, of course, we are preparing also some cases. We will do the protective letters, as I mentioned before. We currently also prepare standalone revocation actions, in fact. But yeah, generally, I don't have much to add to my fellow panelists, very on the point, on the spot. Of course, there's always anxiety with a new system. And this is, as Cohn rightly phrased, a landslide change, tremendous change in patent litigation. Not only in Europe, but on a worldwide scale. But I think from the outset of the system, this is how it meant to be. Within a European single market, we have one uniform decision-making process regarding patent infringement and validity. This is basically meant to be bringing the patent law up to speed with trademark law and design law and other phases. And I think in general, of course, for everyone here involved, it's going to be a hot summer and it's going to be hot next times. But I think we should openly embrace the system, because I think from the outset, it's doing good. And as Mary also mentioned, the rules and the agreement are well drafted. And I think there's good coming from that in the end, if we actively use the system and don't leave it to certain groups of litigators only.
Great. Jeremy.
Thank you. Yes, we have some clients planning to litigate in the UPC, and lots of our clients are opting out. Quite a few just opting out. Everything is a popular strategy, but as mentioned, there are some concerns with it as well. I would say the big picture message of the UPC is that it makes patents granted by the EPO more valuable. I think because of the new court, the possibility of the centralized infringement action means that European patents are going to be used more in what is kind of their intended purpose of litigation, whereas the existing system of national actions, quite expensive and only on a per country basis, lots of patent owners will decide not to go through the cost of litigation. Now that there's a centralized system, I think more companies will, so I think we'll see more litigation. And because of that and the increased value of the patents, I think we'll see more oppositions as well and more patent applications filed at the EPO. So I think for everyone, wherever you're based, Europe should be in particular on your radar at the moment due to these changes coming. Thanks.
Super comments. Annette.
So I have a quasi-personal professional observation and one recommendation. The UPC was set up to simplify everything, and for the time being, it'll do something very different. It will add another layer of complexity to European patent litigation, which has always been complex, and it's just going to change a bit. So that's my personal observation. I know it's frustrating for clients, so let's not talk about fun for lawyers. I very much agree with what Mario said. Please make your decisions on a case-by-case basis. And don't panic because the sunrise period is about to end. If you want to retain some flexibility and watch what's happening, you can still wait a bit, hopefully avoid a lock-in, but you really need to make up your mind before you start enforcing, because even if you decide to take the national route, the accused might retaliate with a central validity attack or might apply for a finding of non-infringement with the UPC. And the consequence will be that you, as the patentee, will be forcefully drawn into the new system, which you perhaps wanted to avoid. So enforcement or threatening enforcement is the point in time when you need to decide.
So thank you, panelists. A couple points before I close. First of all, I think it's very clear that each of us needs to now go out to the people that are counting on us, our clients and others, and try to start a conversation with them about this new development, which I personally believe, having been in this business too long, is the most significant development globally in intellectual property in many, many years, perhaps since 2011-12, when the America Invents Act became live in the United States. I can say that many US companies are way behind the curve in terms of their understanding. And I support everything that Jeff has said about the idea that you need to be ready. You need to have a team. The people on this presentation, frankly, are some of the very, very best in the world. They've taken the time. They understand what to do. I suggest that if you have questions, you reach out to them individually as you deem fit. I also want to thank Griffin and his firm and the people at AT&T, at the USIPA and the Global IPLA for allowing us to have this conversation today. I again say to all of you that this is a educational discussion. We're not providing legal advice. This is a disclaimer. The views stated by our speakers are their individual observations. They don't necessarily reflect their firm or their clients or others. So with that, I turn it back to you, Nikhil. Thank you very much for this opportunity. Hopefully we'll be able to update this in a couple of months from now, since so much will probably happen between now and then.
Yes, thank you, Rob, and thank you for the esteemed panel here. Great discussion. Great. I'm sure there's a lot to learn and a lot to sift through as we move forward towards our deadline. Thank you again on behalf of the USIP Alliance and the Global IP Alliance for being here. We will wrap this session up, and we will have more sessions as we see interest and more as people understand more about what's happening and how they can be up to date on what needs to be done. Thank you all.
Thank you.
Stop recording. Thanks.
Thank you.